Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. First video in 2023. Therefore, I am starting it with the shloka from Ramayana, Valmiki Ramayana. Not me, of course. Justice G. Swaminathan, Mr. G.R. Swaminathan of Madras High Court. He has discussed regarding a slogan in or sloka in Valmiki Ramayana regarding the lessening of punishment. The persons deserve the so-called relief in the punishment. So, you all know that Article 72 of the Constitution of India gives powers to the President of India for the remission of sentence, for the tendering of pardon. So, even though the person is convicted for life, even though the person is given the capital punishment like death, of course, as per Article 72 of the Constitution of India, if the President is pleased that there is a change or there is likely to reform for him, definitely the President of India can tender pardon to such fellows. So many instances have come. Just like Vijayavardhan Rao of the so-called Chilakalurpeta bus burning case. Even though he and Chalapati, both of them, were given death sentence, but still incidentally it has been not executed and now they are in Rajahmundry jail. No problem. Because even though our law, our legal system, our constitution, all these things started with the concept of the police state, now we are in the realm of the reformative stage. Even the prisons, you see, the preamble of the Prisons Act, it also says that everybody is not born as a criminal. The circumstances made him so. There is every chance for him to convert or to reform and come into the public domain. So therefore, the object of the prison correctional homes is to reform him to become into the mainstream of the society. Right. Sometimes we discussed Article 72, which gives the executive powers to the President of India to give the so-called tender of pardon. Likewise, 432 CRPC also told you that is a remission of sentence or suspension of sentence. Suppose if the appropriate government desires the punishment given to a person is not, it should be lessened, yes, using their special powers under section 432, yes, they can remit the sentence also. So this is the thing what happened, which happened in Rajiv Gandhi case. The 6 convicts, Nalini and others, you may be knowing, very recently they were released by the orders of the Honorable Supreme Court of India. Why all these things we are discussing is, so the punishment can be lessened. The punishment can be taken away. So, no doubt, you may be under the impression that when once a person commits a murder, he should be punished. But if there is some chance of reformation, it can be lessened also. This is what Article 72 and 432 CRPC disclose. So, Honorable Justice G.R. Swaminathan, while speaking on the National Conference of Akhila Bharatiya Adhivakta Parishad, so during the Corona season, we used to hear their lectures and very good eminent jurists like Swaminathan. They have held different topics and they used to discuss and we used to hear such things. So Akhila Bharat Adhivakta Parishad, it is one such a good institution where legal luminaries, they will they will take up the topics and disclose their experiences. So while speaking on the 16th National Conference in Kurukshetra University, Haryana, Justice G.R. Swaminathan said, the passage from the Valmiki Ramayana tells the provisions of the revision of sentence. Of course, I told you the lessening, revision of sentence, and it is called as Bharatiya jurisprudence, Shikshastra jurisprudence, let us call Indian jurisprudence. So normally, while discussing the class of jurisprudence in the initial stage, I told you that the system of legal law was not well organized Before or pre-British period in ancient India, only kings used to conduct the courts, then the Mughal emperors, then the British system, then only it was properly codified, all these things I told you. But here, the message from Valmiki Ramayana, there itself it shows the sentence can be lessened if there is a chance of reformation. So, Justice G.R. Swaminathan, he illustrated one beautiful passage from the Valmiki Ramayana where Hanuman actually, and you all know that Hanuman goes to know the whereabouts of Sita. He found the whereabouts of Sita. He will set fire to the Lanka and comes back. Then the Rama Ravana Yuddha, the war takes place ultimately. So Sita Devi comes back. At that time, Hanuman asks Sita Devi, he wanted to kill the Rakshasis who tormented or who propagated that king. You let her go and have contact with that Ravana. So he wanted to kill them. But Sita Devi said no. After all, they have done their duty. They are employed by King Ravana. So therefore they have to do. So even though they committed an offense, you have to excuse them. So this is the wording for Sita Devi, Sita Mata. So the person should be pardoned. So therefore, Honorable Supreme Court of India in that Rajiv Gandhi case, yes, they have released them. So because of the so-called already 30 years they have spent in jail, even after the assassination of Rajiv Gandhi on May 21st, 1991, if I am correct, right? So, Supreme, one of the convicts, of course, he was a star speaker. He read the Ramayana sloka. So previously, even Justice Abdul Nazir also, he stated that Indian jurisprudence has to be taken into account. Of course, there were some comments on him. It has come in paper also. Objection, Your Honor. Of course, critics will always be there. But anyway, so please remember, right from Ramayana days, the concept of revision of judgment is there. So this is the basis. If you understand this, it is sufficient. So with this, I am concluding. It is only a general provision. So since we are beginning with the New Year, so let us have a compassionate mind, as stated by Justice G.R. Swaminathan regarding the revision of sentence, as stated in Valmiki Ramayana. With this, I am concluding. Thank you very much.